This video is to accompany your reading of Shaffer. Shaffer deals with a topic we haven't seen since Pennoyer, and that is of jurisdiction that's either in rem or quasi in rem. So let's just take a moment to review what in rem and quasi in rem is and how it's different from all the cases we've been reading since International Shoe, which were in personam cases. Now, you should remember rem is property, and so what we're looking at is property in the forum in which the defendant is being sued. In a traditional in rem case, the dispute is about the ownership of the property. So if Blackacre is in the state of Ohio and we're suing the defendant in Ohio about the ownership of Blackacre, then it's an in rem action. And those disputes are limited to the value of the property, but that's what the dispute is about. I want Blackacre, I win because I show title is mine, I get to take Blackacre. Quasi in rem is the unusual kind of suit where the property's in the forum and you're using that as a basis to exercise personal jurisdiction over the defendant. But the claim you're bringing is not about the ownership of that property. That's why it's quasi in rem. The quasi part is you're really suing about a personal obligation, a breach of contract, a tort. When you use quasi in rem, you're limited to the value of the property that you're using to secure personal jurisdiction over the defendant. And if you remember from Pennoyer, the way to create in rem or quasi in rem jurisdiction is to identify property in the state and attach it at the beginning of the lawsuit in order to secure personal jurisdiction over the out-of-state resident. The problem is, after Pennoyer, we get this whole new paradigm known as International Shoe, which we've been spending a lot of time on, which brought the concept of personal jurisdiction fully under the 14th Amendment Due Process Clause with a constitutionality test based on minimum contacts in the forum and fair play substantial justice. International Shoe is an in personam action, one where you're suing for a personal obligation and not attaching property or using property only as the basis for the exercise of jurisdiction, but rather the defendant's entire context in the forum and their relationship to the claim. So the question before the court in Shaffer was, what do we do? Does International Shoe apply to property-based personal jurisdiction, or is Pennoyer the only test that is still applicable? In other words, if you just attach the property at the beginning of the suit, are you done, or do you still need to consider International Shoe? All right, there were several critics that the court takes head on in telling us that we shouldn't use International Shoe for property-based PJs, for in rem or quasi in rem. And Marshall addresses these on your casebook on pages 132 to 133. And what I want to do now is focus on those arguments and how he addresses them and handles them. And so I want you to actually have this section of your book out. If you haven't already, make sure you read the case on your own and come back to the video. And when you get to the section on 132 or 133, pause and focus on that part here because we're going to talk about it together. All right, so the first argument that Marshall takes on that critics say is this one, that defendants will avoid paying debts by moving their property to states where they have no other contacts. So in other words, if you use International Shoe now as the paradigm test for all forms of personal jurisdiction, including quasi in rem or in rem, you're incentivizing this transfer of property to a place that you have no other contacts with and trying to shelter it by saying, look, you can't exercise PJ over me by attaching this property because I have no other contacts there and there's no way that you'd be able to satisfy International Shoe. So Marshall addresses this on page 132, the very bottom paragraph, and says the primary rationale for treating the presence of property as a sufficient basis for jurisdiction to adjudicate claims over which the state would not have jurisdiction if International Shoe applied is that the wrongdoer should not be able to avoid payment of his obligations by the expedient of removing his assets to a place where he is not subject to an in personam suit. So that's what this basically is saying, that you're trying to hide your assets in a forum where you'd never be able to reach minimum contacts, and that Pennoyer, if we applied it in its pure form, would have given PJ when someone tries to take their assets in a different state, because you could attach the property and you'd have PJ at least limited to the value of the property. And so Marshall addresses this in that paragraph, which continues onto page 133. And basically his argument is that This really isn't true. Pennoyer itself never looked to the purpose of the property's existence in the state, and the tests that we've used now focuses on purposeful behavior, and that's something that they want to continue to do. And he said, look, if you see this situation happening where someone is moving their property around, it's not true that they can shelter it from all judgments. People can still secure a judgment with that property. All they need to do is find a forum in which you have in personam PJ, or a forum in which you're able to meet the international shoe test, get a valid judgment against the defendant in that forum, and then take the judgment to the forum in which the property is now located and execute the judgment against that property. That's the essence of the full faith and credit clause, that other states have to honor valid judgments by courts of other states. And so this kind of critique is really one that has no teeth. Even if international shoe might make it a little bit harder because you have to take a multi-step approach to get to the property, it will not shelter property and allow defendants to avoid paying their obligations by moving their property around, because all we have to do is just get a valid judgment and then go find the property in the other state and use the full faith and credit clause to enforce the judgment against that property. The second critique is in the following paragraph on page 133, and in a nutshell it was this: that international shoe is uncertain. You never really get a clear answer, and you might be able to appreciate this more as a student now that you've seen so many iterations of application of the international shoe test. Marshall addresses this on the second paragraph on page 133, and his phrase is such: it might also be suggested that allowing in rem jurisdiction avoids the uncertainty inherent in the international shoe standard and assures a plaintiff of a forum. And while your casebook author edits this critique down significantly, it really boils down to the simple response you see here from Marshall, that the vast majority of cases will be easy to apply. It's only the ones where PJ is less clear that you actually see litigation surrounding personal jurisdiction. And he says that's okay. When it's not easy to apply, we're willing to accept that problem of international shoe because it's not a sacrifice that the court is willing to make to trade off fairness for clarity. It's just too high of a cost to say that to make things a super straight bright line would be a willing cost compared to fairness. I think also if you look back to what we saw happening after Pennoyer and the difficulties with a really formalistic judgment, I think you'll see that also Marshall's sort of taking to task that test was ever that much of a bright line because it just didn't seem to comport with realistic patterns of behavior and what we really wanted personal jurisdiction to be able to do. The last critique of don't use the international shoe test was this one, and it was a call to history. It's historically we've always recognized property within a state as being sufficient for jurisdiction, and we should adhere to that long-standing tradition. And this is in the following paragraph on page 133. It starts, "We are left then to consider the significance of the long history of jurisdiction based solely on the presence of property in a state." And Marshall here says, in response, history is not automatic, that ancient forms of PJ are no longer used can offend fair play and substantial justice just as easily as new forms of personal jurisdiction, that the history is not enough alone. I think you can probably guess who is going to later join the court in writing in this opinion, in a future opinion, that will later disagree with this critique of how much weight should be given to the historical uses of personal jurisdiction, and we'll see that coming up very soon. All right, so what is the holding in a nutshell with respect to the international shoe test? Marshall phrases it as such: "We therefore conclude that all assertions of state court jurisdiction must be evaluated according to the standards set forth in international shoe and its progeny." And you see this in the bottom of page 133. If you think about that, that's an extremely broad statement of the holding, that all forms of PJ are now part of international shoe. And we'll see the court take issue with this sort of a statement coming up. But I wanted to put that out there because we'll see a little bit of backpedaling in the future. What I want you to do now is look through the opinions for the application of the international shoe test. What you'll see is that all justices agree that international shoe should apply in this kind of a case, in rem and in quasi in rem, or at least for the most part. So what I want you to do is work through their opinions to determine how each applies the international shoe test to the facts in Shaffer, and then work through the quiz questions posted on Twen regarding application of Shaffer, and post your answers to those Twen questions by 10 a.m. on our class on Friday so we can use those meaningfully in class.